All right, welcome everybody. My name is Jamal Abdi. I'm the president of the National Iranian American Council. We're the largest Iranian American grassroots organization working to build power for our community and our allies, to advance peace and diplomacy, to protect civil rights for all Americans, and to secure equitable immigration policies. Very pleased to be hosting this great panel today. This is part of NIAC's Iranian American Rights Project. If you'd like to learn more, you can visit niacouncil.org/IA rights. Today's panel is entitled Protecting Against Discriminatory Bank Account Closures. Due to broad-based sanctions against Iran, as well as policies like the Patriot Act that were adopted in the aftermath of September 11th, Iranian Americans and the broader MENA community in the United States have faced widespread discrimination from U.S. financial institutions. We in the Iranian American community know of these cases well. In 2007, there was the notorious case of a prominent Iranian American academic who was detained in Iran on false and politicized charges. She was put in solitary confinement in Evin prison, and within a week, Citibank sent her husband a notice that they were closing all of their accounts because she was now a resident of Iran. There have been cases of Iranian students who have been particularly punished by these discriminatory policies. In two cases, in 2013 and 2014, banks in Minnesota and Hawaii began closing all the accounts of Iranian students studying in the United States. In the former case, TCF Bank had an exclusive deal with the University of Minnesota to provide checking accounts for their students. And so when TCF Bank decided unilaterally and often without warning to close all of the Iranian students' accounts, those students were often left without recourse to pay for rent, to buy groceries, and were essentially in limbo until they could figure out how to have a bank account. In the latter case, in Hawaii, the Bank of Hawaii actually decided they were going to work to help their customers. And we worked with them to resolve the problem and restore the accounts. And it was happily ever after in this one rare case. However, we have heard countless stories from our members, from Iranian Americans, and from the broader MENA community about personal accounts being closed without warning, of banks refusing to open accounts for them because of their national origin, or of being subjected to excessive and intrusive questioning, ostensibly because of their heritage. It seems no major bank is immune to these practices. We hear about cases from Citibank, from Bank of America, Chase, Wells Fargo. We're also familiar with the indignity of having transactions among friends on Venmo or PayPal flagged because in the subject we put Iranian food or Persian lessons. And while NIAC has through the years worked with these companies and had a good relationship working to try to fix the issue, ultimately we run up against their view that US sanctions require this level of scrutiny. So as we've worked to address these issues, we've talked to the banks, urged them to fix their policies. We've also worked on the federal level to try to secure policy changes that could provide the banks with more maneuverability to not be cutting off bank accounts in the name of sanctions or national security. We've offered recommendations to the Treasury Department on new licensing that could protect our communities from discrimination in the name of sanctions compliance. And yet it has been to little avail and is of little comfort to those who wake up one morning and find out that they no longer have access to their own money. However, there is a glimmer of hope that the tide may be turning. So NIAC has been working along with allied organizations, some of whom are on the panel, as well as members of Congress, to end these practices. And we do expect some important developments coming up. Next week, the House is going to host a hearing in the House Financial Services Committee on some of these issues. And in the coming weeks, we expect further action to press for a solution from some of these lawmakers. Additionally, Bank of America is now in court thanks to a groundbreaking class action lawsuit fighting back against its treatment of an Iranian resident of the United States based in California and many others in the Iranian American community who have faced issues with that bank. We will hear from the lead of that lawsuit today. So why do financial institutions discriminate against members of our community? How do we resolve this challenge? What can you do to protect yourself from having your account closed? We're going to answer those and more questions today. So without further ado, let me introduce our distinguished panel. Mehrnoush Yazdanyar founded Yazdanyar Law Offices in 2009, which focuses on the regulatory enforcement and criminal aspects of sanctions law. During her 10+ years of private practice, Mehrnoush has not only established herself as an expert in her niche areas of practice, but she's also gained esteem for her pro bono and nonprofit work, as well as her dedication to assisting non-governmental organizations with their legal needs. Mehrnoush's advocacy to protect the rights and well-being of her clients has allowed her practice to grow from one office in Beverly Hills to multiple offices throughout California, including Irvine, San Francisco, and Westlake Village, and positioned her firm to help clients nationwide. And I certainly know that we have sent folks to Mehrnoush, and she has been an indispensable resource for our community to navigate this tricky issue of sanctions. Our next panelist is Jason Rathod. He is a founding partner at Migliaccio and Rathod LLP, and is regarded as one of the most accomplished plaintiff side class action lawyers under the age of 40, particularly in the areas of consumer protection and defective products. Mr. Rathod has been appointed to leadership teams in some of the most high profile cases in the country. And in addition to his consumer protection work, he also prosecutes data privacy, wage theft, civil rights, and environmental protection cases. Most importantly, for our purposes in this conversation, Jason is leading the class action lawsuit against Bank of America over its practices. Finally, Gadeir Abbas is an attorney with CAIR, the Council on American Islamic Relations. There, he has argued in federal trial and appellate courts across the country on behalf of Muslims challenging religious discrimination of all kinds, at work, during travel, while incarcerated, on campus, and beyond. These cases have led to settlements, judgments, and injunctions against Alaska, Texas, and Oklahoma, prisons and jails in Virginia and Georgia and Washington State, factories in Colorado and Wisconsin, as well as against anti-Muslim figures and organizations, and against federal agencies. So to start our conversation, I want to start with Mehrnoush, and I'll give everybody a chance to answer this question, but just from a very basic level, Mehrnoush, can you explain what is happening here? Why do banks sometimes engage in these practices where folks are being cut off from their accounts, or they're having their accounts suspended, or they're unable to open accounts? What is the rationale here behind this, behind these practices?
Sure. First of all, I just want to say hello to everyone and thank you, Jamal and NIAC, for putting on these important events, because I do believe educating ourselves in terms of what can go wrong or what can lead to these discriminatory practices is really important in protecting ourselves in the meanwhile while we're looking to fix these issues. And so I've been working in sanctions law for a very, very long time. And yes, there is a discriminatory impact, but from my experience, it's more of the flaws in the regulations and then the way that they are applied that causes these problems. And in particularly when it comes to US banking regulations, the issue is that we have these incredibly ambiguous and convoluted regulations in place that are far more restrictive than people realize, even for dual nationals, when you're a dual national of a targeted country, like myself as an Iranian American. And then the government puts the banks in this very difficult position of regulating or policing these regulations that are ambiguous on its face, and then they also face major penalties if they don't comply with them. And so what ends up happening is, for example, the regulations clearly state that an Iranian American may receive non-commercial personal or family funds from Iran. You can also send it to Iran. The problem is there's no direct banking relationship. You have to move money through a currency exchange broker. And when you do that, which is not illegal under the regulations. However, you have to make sure it comes from a third country account. You have to make sure you notify your bank. This information isn't readily available to most people. So they can at most do the due diligence of saying, okay, my mom, I'm a student here and my family in Iran wants to send me $20,000 to help pay for my tuition and living expenses while I go to school. They can even look on the OFAC website, and that is a completely legal transaction. But how do you get money from Iran to the United States when you can't walk into, for example, Parsian Bank and directly wire money to Bank of America? You have to move money through these money transmittal businesses. On the bank side, when they're receiving money through these informal money transmittal businesses, they don't know what the source of the money is. So they're not sure, is this related to a transaction that required a license? Is it coming from a sanctioned country? What's happening? And so they'll flag these accounts. And then we do have basic regulations like that state and sanctions that, you know, a US depository or institution cannot open, maintain, or operate a bank for someone who is physically resident of Iran or inside Iran. So in the case that Jamal said, the bank is technically not wrong. However, the solution to that would have been, instead of closing that account, saying, apply for a license from the Department of Treasury, we'll restrict this account, money won't come and go until you get the license. And in this instance where someone is in prison in Iran, I'm sure the Treasury would issue a license. So there's these little technicalities, and I think understanding the regulations is incredibly important, but the problem is the regulations are ambiguous. Not everyone knows about them, and then the banks are administering them. And then, to be fair, a lot of times the banks aren't sure what to do. They just hear Iran, and that's where what I really try to prevent is that don't hear the name of a sanctioned country and freak out and say, we don't want to do business with you. We don't want your money. Like in that first case of the banks, be like Bank of Hawaii and say, we want to do this. Let's figure out how to do it. You know, I understand it's hard and it's costly, but it's also, it is unfair to people that are just living their normal lives here. And just because of their dual nationals of a sanctioned country have to endure this. So in a very long way of saying it, I think that the problem is multifold. One is just the regulations themselves. Two is that they're having the banks police these regulations, and also the customers and clients aren't really aware of the full extent of the restrictions that are placed on the banks. So what seems harmless to them can actually.
You know, and so you raise some of these cases. If you're, you know, inside of Iran and you know, we hear from people who, you know, check their balance or go to make a bill payment and they're inside of Iran, they're normally in the United States, they're visiting, they access their bank, it gets shut down because the bank can't provide those services to a person in Iran. And some of the other ones. We hear from people who there's seemingly no explanation. They haven't visited Iran recently. They haven't had any transactions with Iran, and it seems like it's a matter of either, you know, their national origin or their name, the algorithm that the banks use picked something up that for some reason made them think, okay, we need to either terminate this account or send these questionnaires about where have you traveled over the past several years and all of these other questions. So is this just a matter of the banks attempting to comply with these regulations and not really having a nuanced approach to it, or how do we explain these scenarios?
So in my practice, my experience has been when an account has been closed, I want to say 99.9% of the time, there was something that triggered it. And it sometimes took us a long time to figure out what that trigger point was, because like I said, the client is thinking, I didn't do anything wrong. But for example, when we talk about moving money through these currency exchange brokers, the way it works is you give reals to this, or the currency of that country to them in that country. So we'll just use Iran. And then they give you the equivalent here in the United States. And they can do that by sending it from a third country or by depositing it from inside the United States, which is not legal. The second one is not legal. That looks a lot like if someone has a cash business, right? So like if someone is depositing $5,000, $6,000, $8,000 randomly into someone's account, that looks the same as, for example, if you have a cash business where someone is giving a lot of over-the-counter deposits, or randomly you have a larger cash deposit or something like that. Usually there's something that mimics one of these foreign transactions that gets flagged. Or, for example, you just receive a payment from a third country out of the blue, or there is something in the wire instruction that triggers it. In a very small number of cases, I have had people that have called and said, I have done nothing. I haven't received any money. I haven't done any different kind of banking. I don't do cash. I get my, it's whatever it is. And they closed it. And most of those have been linked to, the banks do send documents of asking you to update your information as well as your residency information, because it doesn't matter if you're a citizen, it's where do you reside, and that matters to them. And a lot of times people don't answer the questions, or don't get the letter, or don't get it on their mobile banking, or whatever it is, and they don't respond to it within that certain time period, and then they close the account or they restrict the account. And since working with NIAC, because I know you do handle a larger part. I mean, people come to me when something is related to sanctions. That's why most likely the people that have come to me, there is something that's triggered having to do with Iran. I have become aware of, and I believe maybe some of the other panelists can speak to this issue, where it is nothing. It is basically the name. They've done everything correctly. They weren't sent anything and the account was closed. And I personally would love to get more information on those, because the other ones I can explain. I mean, it goes back, it's not fair, and it's so frustrating, and it is a little over compliant. It is stemming from over compliant behavior, but at least it's rooted in something. If I'm physically in Iran and I do mobile banking, as ridiculous as it sounds, because if I was French and I was in Paris and I was doing it, it wouldn't be a problem. But if I'm paying my own bill and nothing has anything to do with any other foreign country, I just go online and they detect that I'm in Iran, they can restrict the account, they can close the account, they could do whatever. And that's unfair, but there is a basis in the law that justifies that. And that says that US depository institutions cannot maintain and operate an account for any person who's physically present in Iran, which goes back to, well, then there's a flaw in the law, because that doesn't work with the way that we are. Like, doesn't work with the current country that you're targeting, and the fact that the last time these statistics came out, it was like 2 million Iranian Americans. Well, of course, someone's going to travel to Iran. What are they supposed to do? Suspend banking, So, but most of my experience has been something has triggered it, or there is something that we can look back. It's ridiculous often, but there's something that's there.
Gadeir, let's turn to you. Sometimes, Iranian Americans, even at NIAC, we've looked at these issues in a silo without realizing these are widespread, and they affect, the full, MENA community. And I know that you've done a lot of work on this. So sort of more broadly, what do you see on this front?
Yeah, I think we've been investigating for years the connection between the federal government's terrorist watch list and the banking system. In our experience, the federal government's watch listing decisions usually accompany some kind of obstacle. Maybe it's the person can't wire money anymore. Maybe their bank accounts are getting closed, or people that they're related to or associated with. And so we've been investigating, and we still don't really know what that connection is, but it is clear, I think, to us that the banks are reacting to the federal law enforcement's perception of where the threats are, who's dangerous, what's suspicious. And there's definitely a policy infrastructure that focuses people's attention on Iranian Americans, on Muslims, pretty much anybody east or south of the Mediterranean. And so, in our experience, it's just easier for the bank to reflect what they think the government would want them to do. And that ultimately, I think, reflects some kind of social bigotry towards, people in the Middle East and North Africa, anybody perceived as dangerous. I bet in the coming years, we'll see bank account closures of Russian nationals or Chinese Americans. And so it is about, I think, and one of the challenges is how do you get law enforcement to stop telling the banks or approaching the banks with a focus on these communities. We'll see sometimes it's a person's designation on a watch list that it becomes the basis for FBI agents approaching the bank and inquiring further about their bank account, and they know exactly what they're doing. A bank is going to just close that person's account right after the meeting without any additional steps, because the watch list allows the government to communicate some official designation to the bank. And so whatever the connections are between the watch list and the financial system now, if it is I think an area that we're really concerned that if you're trying to exclude certain categories of transactions or certain kinds of people from certain kinds of transactions, you would build an international watch listing system that you could kind of in bulk assign statuses to people. And so I think ultimately that the unfairness or the overcompliance is an effort by the banks to do what they think the government wants them to do.
We have somebody entered in the question field. I'm hearing people have zero recourse, but to tolerate indefinite surveillance, intrusion, whatever else federal agents decide to invent to do to an individual. So I want to talk about recourse, and we'll get to, at the policy level and at the personal level, but I want to turn the conversation to Jason. So Jason, can you tell us about this class action lawsuit against Bank of America and what recourse this may provide?
Yeah, absolutely. Thank you. So we filed this case on behalf of an individual who resides in San Diego. He's an immigrant from Iran. He came as a physics PhD student in 2011 to the United States. He opened an account, a credit card account with Bank of America in 2015. He complied, with their stated requirements of residency. So he, periodically submitted his residency documents. But then in 2019, basically without explanation or without adequate explanation, Bank of America first restricted his account and then ultimately closed it. And, the inquiries that he made at the time, they didn't, make any sense for what Bank of America said as the reason for closing it, because he provided the documents that they asked for and that they said were acceptable to establish his residency. And so from my understanding that this is a pretty common story, or one that's heard a lot. And in the class action complaint that we filed, we kind of cataloged the different sources of these stories that we hear from people. So there's his story, but then there's also the Consumer Financial Protection Bureau, which is the regulator of the banks, one of the regulators. They receive complaints from people. And so we put a listing of all the complaints that they had received, complaints that organizations like NIAC had received, so complaints on social media and elsewhere. And so we cataloged all of those to say that, look, this isn't an isolated occurrence, but there's a pattern here of discrimination against persons of Iranian origin or persons from the broader Middle East with these practices. And so we filed the complaint. It alleged, the most straightforward claim is probably under the Equal Credit Opportunity Act, which if there's an adverse action taken against your credit card account, you're entitled from the bank to receive a statement of reasons why, a written statement of reasons why that happened. And our client, he did not receive that. And that is to help ferret out discrimination so that a bank has to explain exactly why they did what they did. And so if you don't receive that, then that's a violation of that law. And then also we have legal claims under a variety of state and federal civil rights statutes. Bank of America moved to dismiss the case last winter, and we opposed that. They moved to dismiss all the claims, and the judge in the federal district court there, she denied the motion to dismiss in its entirety. So all claims are moving forward. We're about to begin the discovery phase of litigation. And so it's, it's an exciting development. We're hopeful that with the class action lawsuit, what we could achieve is primarily, and there's, kind of a battery of relief we're seeking, but primarily a change in practices with Bank of America so that they could look closer at what it sounds like the Bank of Hawaii ended up doing, which is, being able to comply with whatever laws that they need to, but do so in a non-discriminatory manner. And in addition to those changes of practices, also to give people payment for suffering the indignity of discrimination, as well as other harms that they may have suffered, such as, damage to their credit score, as well as, loss of credit card reward points, various things that they may have suffered as well in terms of compensatory damages, statutory damages, and we're also seeking punitive damages. So that, in a broad sense, is what the class action encompasses.
And while realizing, this is an ongoing legal matter, so you may be limited in what you're able to talk about, I'm just curious, I mean, how big of a deal was it that this was not, the motion to dismiss was rejected? We'd heard for years just about how difficult the legal path would be and how, this is a national security issue. And so, most judges will defer to the government on these things. Obviously, you're not suing the government in this case, but how significant is it that this was rejected, or how surprising is it?
I was, we were all obviously very pleased with the court's decision in rejecting the motion to dismiss because it really validated the core legal theories of the case. And Bank of America did kind of trot out these arguments about, sort of the Bank Secrecy Act compels us to do this, the OFAC, these Treasury regulations, they compel us to do it. We were able to cite some cases that said, look, none of these laws require you to engage in discrimination. They may require you to do certain things, but you're not allowed to engage in wholesale discrimination against a group of people. And so I think that really just demonstrated the core validity of our legal theories, that there's a way to comply with the regulations that you may need to, but to do so in a non-discriminatory manner.
So I'd be interested to hear from the panel, what are your thoughts about, beyond the sort of legal recourse, we're hearing that this is largely driven by federal, law and regulations. So what are the solutions to not just put out fires individually, but to actually protect our communities from this type of behavior? What needs to happen, whether it's at the regulatory level or legislative level? Do you have thoughts on that? And is there anything, is there something that is more promising, a pathway that is you see as most viable to actually fixing some of these things? And I don't know if anybody wants to take the lead on responding. Otherwise, I'll just volunteer somebody.
I can go. So we have worked with U.S. banks. We actually do work with Bank of America and Wells Fargo specifically, where it took a long time to get there, but we figured out a system of working with their compliance department to notify them when someone is expecting transactions coming from Iran. And that's helped a tremendous amount. There's a lot of other banks that are interested in doing it. The smaller banks, it seems as if it's not that they don't want to do it, but because these things cost a lot of money. I mean, to have these checks on these incoming wires and looking at them and making sure that they aren't related to anyone that can trigger any issues with the sanctions regulations or whatever, it's hard. And that has worked. A lot of times notifying the bank when something goes wrong before it's been escalated has been helpful. But we have had a lot of cases where, they'll get a letter, and I'm curious now, maybe I can just refer them to Jason if this happens in the future, but they'll get a letter that's basically saying, we're going to close your account. And when you sign an agreement with the bank, that agreement says the client, you or the bank at any point can decide to terminate this. And we're exercising that right without any further explanation. And that's what's incredibly frustrating for people, because they've received money they believe to be legal and it's coming from someplace, and it just triggers something. And after 40 years, and imagine like someone literally has been banking with someone, their business, personal, everything for 40 years, and then they just close all the accounts, So we've had success working with the banks to a certain degree, but there's so much like Jamal, what you're saying is it's hard to go case by case basis. Like, we've had success in obtaining licenses for people to maintain bank, like to be able to travel to Iran and that not impacted. But the big issue is education of the laws, so that you don't, because as unfair as it is, once it happens, undoing that is incredibly difficult. So I would say the first thing that we as individuals could do is just get an idea of what your rights are. What is illegal, what is not illegal, as unfair as it may be, just so that you kind of know, because a lot of these things are little changes that you could do. Jamal, you used the example of Venmo. We worked with your organization, with NIAC, to have a dialogue, and they were really open to it, to understanding what can go wrong, what's legal, because a lot of times the banks will cite sanctions as a problem, as a reason for rejecting funds, but the transaction at issue is completely within that law, that they are wrong in doing that. They are over compliant and they're misapplying the law. And so having the banks understand the law, that it's not everything coming from Iran is illegal. It's not every time you travel to Iran, it's illegal. There are exceptions, and understanding those exceptions and incorporating them, and then educating your own personnel. I mean, the banks should educate it. The people at the branch who have the most contact with individuals really don't know what the laws are. And so we have everything from, if you walk in and say, I'm receiving a wire from Iran, they'll flag your account to close it, to they'll tell you, oh, no, bring it, it's not a problem. Both of those are wrong. So education for the people, education for the banks and the people that are applying these regulations, but also for the federal government to understand that they need to change these laws, or address these issues, because they're in the position to do that. I mean, they're in the position they could very easily issue a general license that says, if someone is traveling to Iran, they can notify their bank, and provide, proof that they're still residing in the US, that their bank, like putting things in place that channels, there's easy solutions for a lot of these issues, but I think it needs to come from the government level. And I think they don't understand the impact of it, or they're starting to with cases like this. I think this is going to make people aware of it, because it's just so easy to fall into that trap of hearing Iran and being like, well, there's something wrong. Something is happening, or like, who cares? And then when you think about it, oh, I'm just bringing my own money, or I'm a student here and I'm paying tuition, and I can't do that, or you close my accounts, and then people understand how unfair it is anywhere in the world, but especially in a country that says that we don't want to engage in these types of activities. So I would say changes will occur if people educate themselves on their own rights, to kind of try to avoid what they can avoid. If the banks do a better job of understanding what their clients are doing, the basis of those underlying activities and transactions, without just blanket, if it involves a sanctioned country, closing it, and the federal government, specifically OFAC, really looking at how these laws can be applied in a way that doesn't carry out the intent of those regulations, and that does have maybe an unintended but very real discriminatory impact on this group of your own citizens. And
Gadeir, do you want to weigh in on potential advocacy or ongoing advocacy efforts? I know there have been congressional letters. There's been focus on banking while Muslim, and trying to get some protections. But what are you looking at in that regard?
Yeah, I mean, it does seem that there's a kind of a hole in the legal protections people have, where it's okay for the bank to make a financial decision to not do business with you because they perceive the cost of compliance associated with the financial activity you want to do as not worth the account. And that's, banking is a numbers game. And so it's, if you look at any individual account, it's going to be easy, I think, to conjure up some kind of cookie cutter explanation that, the cost of doing business with you is not worth the value of doing business with you. And so, I think there needs to be some sort of legal framework for when they can open and close bank accounts, or prohibit people from using any other kind of financial services beyond, what exists now. I think, under federal law, there are regulations, and then there's 1981, which prohibits private parties from making race-based contract decisions. But some of these issues in bank account closures, I think, play along definitely national origin lines, around religious lines, around ethnic lines. And so I think the protections should be bank specific and obligate banks or some kind of subset of maybe the bigger banks to take on the cost of compliance and set aside the cost of compliance as a reason for closing anybody's bank account. But I'm sorry, on the advocacy part, I do think that there is it's not okay if your bank account gets closed. That's not an acceptable thing in the United States. You should not be shut out of financial services in this country. And so if your bank account gets closed, look at all these nice people that are eager to help you. And so I think that's an important part. If something bad happens, if not for you, for the next person that comes along trying to do business with the bank that did something bad to you, stand up and try to advocate for a change.
Yeah, I was going to just going to add on to what Gadeir said there, that in our complaint, it was one of the key things that we were able to point to was this collection of complaints from people. So it was really important that people did speak up, and that made our case seem more plausible that this wasn't just an individual act of discrimination, but we were able to point to a broader set of evidence, and that really, I think, helped us at this early stage of the case. And so if something does happen to you, tell an organization, tell one of us here. You can also complain to the Consumer Financial Protection Bureau or the bank. But I think it is important, I guess, wherever you sit, if you're a consumer, or also for other people, if you're an advocate, this is an important issue. If you're in compliance, there's a role for you to play. In another case that we saw, this was pending, I think, in Ohio, and then it went up to the Sixth Circuit Court of Appeals. But one of the facts there was that actually a bank compliance officer, he noticed that every month he was getting a list of accounts to close, and that disproportionately contained the names of people of Middle Eastern backgrounds. And he came to a lawyer and said, this doesn't feel right to me. And that was a major helpful piece of information. In that case, it was against Huntington Bank. So wherever you stand, there's important ways that you can play a role in fighting these practices.
I'm curious, this has come up, and Jason, you mentioned it. Is there a role for the Consumer Finance Protection Bureau here? And if something we've considered is, so we hear from somebody, they're having this issue, we, send them to, get some legal representation or at least legal advice. Is it worthwhile for them to be reporting this to CFPB, or is there any teeth there, or, what can they do? Or is that sort of just a path to document this and then hope, if there's maybe a lawsuit in the future, it can be, those complaints can be relied on. But what is the role there? Is there anything CFPB can do?
Yeah, so the CFPB does help administer the Equal Credit Opportunity Act. So if it is widespread that with credit transactions, people are getting their accounts closed and they're not getting a statement of reasons as to why, just to give one example, but also, the discriminatory aspect of it. The CFPB is the appropriate regulator overseeing that statute. So I think the greater the volume of complaints that they receive, the more likely they are to look into it further and potentially bring an enforcement action, or at least to, start to work with the banks directly. So I do think that there is possibly an avenue, first and foremost, just to get it documented and get it out there through their complaint database system, which is freely open to the public. You could search, but also that it could give the CFPB a heads up that, hey, there's a real problem hearing, you should look into it. And they have statutory authority to look into it.
Got it. All right. So one of the questions that I have here is, somebody says Bank of America, I guess from personal experience, Bank of America specifically asks its customers whether they are dual citizens. Are they legally allowed to ask that question? And are customers legally bound to provide an answer?
It might be more for Mehrnoush, potentially.
So years ago, I was on a panel with a representative. It was for the Iranian American Bar Association. And I think, Jamal, you were there, but I don't know if you were on this particular, I don't think you were on the sanctions panel, but I think you were there. But anyway, we had a representative from Bank of America come, and that was one of my questions to him, was because they were asking this question. So I think obviously the bank can ask it and you don't have to respond to it. So my thing was, well, if you respond to it, is that going to then, put you at a heightened level of scrutiny and your transactions at a heightened level of scrutiny if you are from a sanctioned country? But what he was saying is that the flip side of that is, when they know you're a dual national and they see irregulatory activity, like something coming in, like the money deposits that I was talking about, and they see that, they're more likely to ask you what is the origin of the funds versus just jumping to closing the account or restricting it or blocking that transaction, which was interesting to hear. I don't know which side of that I both of them make me nervous, because I do feel like, well, why does it matter to you? From a legal perspective, all the bank can and ask you for is, where do you reside? Like, where is your residency? Where are you living? And that information makes a difference in terms of whether or not they are allowed to have a bank account for you, or how they can manage that bank account for you from a federal law perspective. The dual national side, I don't think that that is something they can ask you, and I don't think you have to answer. And the way from what my understanding of the law and all the regulations I'm aware of, I don't think that makes any difference. I do see what he's saying, like that would helpful if you answer yes and there isn't a transaction, because it's not every case that something, and my perspective is different. And that's why I really was excited to be on this panel, because of my area of law, people come to me when they've done something with Iran and something went wrong, and then we're here, right? So it's not like what the experience of our other panelists have been, where it's someone that hasn't done anything wrong. They're just going about their business and they're having these accounts that are closed. So for us, it was always linked to something, and opening up that dialogue with the bank and kind of developing transparency has been helpful. So I can see how that question would be helpful for the bank. You're not legally required to answer it, but I don't know if, and so he had said on that panel, and this was years ago, but he had said, no, you don't have to answer it. You don't have to answer any of those things, but there's certain required answers that you have to give. That definitely do that, because then that gives them grounds to close your account if you don't.
So you don't have to answer it. They can't use that answer against you. They can't say.
That's the thing. Like, how do you know if someone is using something? And that's the problem, is because they have this ability to say, this is our internal banking issue, or this is just a business decision. This has nothing to do with this information. And how do you prove that that's not correct? On an individual basis. And that's very frustrating, because it's obviously that's not the case. Obviously, this is beyond just being a business decision. And like I said, in certain cases, I can see it. If you received, $100,000 transaction from Iran, and your broker deposited into your account in like 9,500 increments, over the counter deposits of, that's legit. That's not just a sanctions issue. That's a banking law regulation issue. That's a structuring issue and whatnot. But there are cases where, you've given the bank all the information, everything has happened, and they'll close it and they won't tell you why. And so I'm actually curious, Jason, if it's okay, I might contact you offline to get a little bit more information in terms of what we can have. It's not what I do, but if I can actually help them, file a complaint or get more information or exercise certain rights that they may have that may not be aware of to get more information, to put the banks in a position of having to answer those questions. Yes, we closed this account, but this is why. I think that in and of itself would be very satisfying group of people.
Yeah, absolutely. I'd be happy to be in touch with you, or really anyone else who has any questions.
Let's see, I'm looking through some of these questions that we've got. So I have one question about the regulations that Mehrnoush raised. And do they apply specifically to Iran, or do they apply to all OFAC sanctioned countries, including Syria and Iraq? So maybe we can, Gadeir, like, are there, I mean, we see, kind of Patriot Act, terrorism and anti-money laundering regulations. We've got that, and then we've got the sanctions layer. So with these other sanctioned countries, and I guess maybe even designated state sponsors of terror, are we seeing similar? Are there similar regulations in place, and do we see similar backlash for customers that are from those countries originally?
I can't speak to the regulation specifically, but it just everybody that is from an area that like a country that has a dispute with the United States is having a problem. It's Iraq, Iran, Syria, of course, and beyond. And I think it's just in the structure of the situation. There is this big edifice of regulations, but there's also just what are the people at the bank, worried about? What's scarier to them? Is it like someone moving money in and out of Sweden, or is it someone moving money in and out of, a country in the Middle East? And I think that it's not always like a bank account closure or a decision to not allow somebody to wire money. It's not always being made and Mehrnoush should correct me if I'm wrong, but I don't think it's being made at a very high level in the organization. And the people that are making the decision are separated from the people that are dealing with the customer. And so we've seen it where the bank doesn't know why the bank closed the account. It's the branch, it was closed because of some decision that was made elsewhere, and they're not getting the information about it. And so I think there's a lot in the structure of the situation that allows just kind of the social animosity that people have generally, against folks from the Middle East, North Africa, and beyond, or whatever happens to be the concerns. And I think for like Iran and other sanctioned countries, there's like a structure in place to constantly generate animosity and against a group of people, and that just filters inevitably into the decisions that banks make.
So Jamal, if it's, may I, just about the question about, is this just Iran, or is it applicable to other sanctioned countries or targeted countries? And obviously every country that has a sanctions program administered against it by OFAC, or Office of Foreign Assets Control, which is a part of the Department of the Treasury of the United States, they have different sanctions programs. Now, Iran is one of the most comprehensive, but we have had clients coming from other targeted countries, and the almost all of the regulations prohibit importation or exportation of goods and or services to and from that country. And one of the issues that comes up in the banking laws is it financial services? So what aspect of financial services are you doing, or where is this money coming from? Now, what's unique about Iran is that unlike most other sanctioned countries, most of the time people are looking to send money back to those countries. We saw it in Cuba for years and years and years. The family remittance issue was not one of Cubans wanting to send money here to the United States for their loved ones. In most cases, it was vice versa. In Iran, there are millions and millions of dollars that are being sent out of that country by, immigrants who've come here who either can't go back or don't want to go back, or who have assets there, first and second generation, large pieces of land, large properties, estates, inheritances. They're looking to liquidate that and to bring that here. And that's why we see Iran is more on the radar. But these restrictions that are in place are pretty much applicable to all sanctioned countries. So if you are receiving money or if you have family in any of these targeted countries, even if you're not Iranian, a lot of what we discussed today would be applicable to you. And also, if you do want to receive money, it is important for you to take those same steps to ensure compliance. And for what we do is when a client wants to receive money from Iran, and we prepare compliance paperwork that includes a legal memorandum and an affidavit, and we submit it to that bank's sanctions department, compliance department, depending on the bank we're working with, for each incoming wire. And the regulations clearly state, again, this is specific to the Iranian transactions and sanctions regulations, but it would be applicable to any, I'm sure we could apply that to any money that you're bringing from anywhere. It's not legally required for you to submit these documents to the bank. And that's the other issue. If money is generally licensed, meaning it's permitted for you to engage in a certain type of transaction, there is no legal requirement for you to take any additional steps, not with the Treasury, not with your bank. But if you don't, your exposure level is incredibly high. So it is suggested or recommended that you notify your bank of incoming wires. But to Gadeir's point, if you go into your branch and say, I want to do this, I guarantee you, I don't want to put a percentage on it because it's hard to be accurate, but it is incredibly rare for that person that you're going to actually face to face with, that they know what steps you need to take. And that's where it gets problematic. And that's why I tell people, like, don't go to your branch. That's just going to create problems. We're going to work directly with the compliance department, right? But if you are receiving money or if you're doing anything financially from a country that is specifically sanctioned, because I'm talking more about the sanctions regulations because that's my area of expertise. There are steps that you can take to establish transparency that will help reduce the probability that your account will be closed or that it'll be restricted or blocked. And we're happy to talk to you more about that, if that's something that you have questions about.
We've got a number of interesting questions about individual cases that I think are broadly applicable. And so this may actually, you may have actually answered this with your last comments, Mehrnoush, but somebody says, suppose an Iranian American needs to go back to Iran and live there for a couple of years because of a parent's health issue or something like that. Do institutions like Vanguard or Fidelity then have a reason to close the person's retirement account?
So that's a great question. I think yes, because the regulation says that a U.S. depository institution, which those would fall into it, cannot own and maintain or have a bank account for you. But what I would recommend is if something happens that you need to go and live in Iran for a period of time, for a number of levels, you should probably get a license. If you're going to work remotely. Working remotely from a sanctioned country, from the government's viewpoint, is importing services from that country, which is illegal, even if you're working for a US-based company. So even if I go from my law firm and I decide I want to work in Iran for 6 months, that's not permitted. I should get a license. And so you should just apply for a license. You should apply for a license to maintain your accounts. Because what's the worst that can happen? They'll write you a letter saying this is not something, and there's nothing more that they can do. Otherwise, we're going to get Jason involved if they do. So they don't want that. So, so you can absolutely apply for a license, but yeah, they're not supposed to maintain a bank account for you while you're in Iran. And that's a problem in the regulations. I mean, it's just, to me, it seems like a regulation that was written at a time when they did not foresee this many dual nationals coming and going. And, especially after the pandemic and the flexibility of travel. And, if you can go work from somewhere, why not? And if that happens to be a sanctioned country, but you have nothing to do with anything with that country other than the fact that your family lives there, why can't you go? But there are steps to take. Sorry, I get long-winded because I get all excited about this.
All right, a couple other questions. So somebody says, every time I log into my Bank of America account, which I've had for many years, it asks me to identify my country of citizenship. I always decline and say, remind me later. Is this related to the issue being discussed? And then sort of touching on something we covered, but somebody says that they opened an account with KeyBank, and about a week later they were contacted and asked, "Are you planning to visit Iran? Do you have any property in Iran?" And so forth. And so I think the question is, I don't know if we have the answer, but are you required to answer those questions? And I assume the answer is you're not required, but then the bank may decide that they cannot.
The property in Iran, I've never heard. That's kind of ridiculous, because that's definitely not, that's not their business. No different than they don't ask any other nationals of, like, do you have bank accounts anywhere, which from like a IRS perspective, if you have a bank account outside of Iran, you're required to report it. The banks aren't policing that. You're absolutely not required to answer any of that. And you can, you could just even say, I decline to answer, or there's no reason why I need to answer this question, so you definitely don't have to. Yeah, that's very interesting to me. I haven't heard of that. I've heard of the dual national, but I haven't heard of anything else, unless, it's hard for me to speak to an individual bank, and it sounds like that's a smaller financial institution. I'm wondering if that is one of their ways of trying to figure out if the answer yes, it's going to lead, well, if you ever bring money, let us know if it's going to lead to decided that it's a business decision to close your account 6 months down the line,
Right. Yeah. Okay, let's close out. We've got 3 minutes. Unfortunately, I don't know if we have an answer to this question, but somebody asked, are there any banks that are good on these issues? I mentioned Bank of Hawaii. I don't know if anybody else has any experiences. From my experience, every national, major bank is involved in this kind of activity. Does anybody else have any insights?
For me, for our firm, we have been working with, like I said, the compliance departments with both Wells Fargo and Bank of America for clients who are receiving funds from Iran, and very successfully for 13 years now. That's not to say there haven't been account closures. There have been, but those were instances where it was very understandable why the bank would exercise that right. It's been very rare for them just to close an account. So there have been instances, because it's a lot of people, a lot of time, a lot of money in a lot of cases, but we have had success with those two banks for clients looking to send money over. We've had US Bank has actually sponsored a nationwide seminar to talk about these banking regulations, and they've expressed interest in trying to figure out a way to navigate through the regulations to also be able to service the community, which has been great. Just the smaller banks, from my caution, and it's not because they don't care. I think that because they are smaller financial institutions, they don't have the resources to put this in place, or it's a higher risk for them because of a larger penalty. Because what you also have to realize is we can do everything right, and the source of money can be right, and everything can be correct. But because there's no transparent way of moving money, something can go wrong in this that would cause financial hardship for the bank, or expose them to a lot of penalties. And that is that's a real consideration. And I think a lot of this fear is driven by that. But also remember, in the regulations, it says that a financial institution can rely on what a client or customer says in processing transactions. So the more information that you provide, and the more complete that is, and the more transparency it establishes, it reduces the chances of a bank account closure. And I will just say this, is that be careful, though, the information you provide, because something as simple as, I have a bank account in Iran, or this money came from my own bank account in Iran. If I'm a US person, having a bank account in Iran is illegal, even if I report it on my taxes, even if it's a privately owned institution that has nothing to do with the government. So that's grounds for the bank to block that transaction. Or if you sell property that you acquired after you became a US person, that's a transaction that would have required a license from the government, and that's grounds for the bank to close your account. So really understand the law, and then, move transparent.
Yeah, so good luck to ordinary people trying to navigate all this. You need a law degree in order to to bank in the United States in some circumstances, it seems. I want to thank everybody. We're out of time. Thank you, Mehrnoush. Thank you, Gadeir. Thank you, Jason, for all of your work. Looking forward to working together in the future and positive developments on some of these fronts. Let me remind everybody, I think it's in the chat, but we've got links to both NIAC's Iranian American Rights Project, where you can report to us if you've had an issue with your bank, and we can help you navigate that and make referrals or take appropriate action with the bank, as well as Jason has a form to report these closures as well. I think, Jason, I don't know if you want to speak to that quickly.
Yeah, I just dropped, we have a page dedicated to this issue as well, and I just put that in the chat, I think before I'd sent it only to the host, the panelists, but I put it to everyone now. So that it presents some information about the case that we have, and then some other cases involving discrimination against non-citizens that may also be helpful for people to see, and then a form that you could fill out as well. So that is all.
Great. Excellent. Thanks everybody for attending. Thanks to our panelists. And we will see you next time and be working hard.